Or live, man. You can do whatever you want.
Do this. I'm all for live.
All right, we are live on Facebook and on something on YouTube. We're actually streaming live in the Federal Court Immigration Lawyers thing too. We'll see. We got a little eye here, which will show us if anybody starts listening. What I'm going to do is I'm going to put this on podcast though, so it'll be released in podcast form later too. So, welcome to the show. This is
James,
the Prima
good to be here. Good to meet you in person this week.
Yeah, so for the first time, Brad and I met in person in the lovely town of Cincinnati, where I became a sports fan for the first time. I am the newest Cincinnati Reds sports fan. Do you realize, so I think I don't know if I was telling you or DJ that, like, when we first got there, I was like, yeah, I really don't care about sports. I never get into it. I don't even care about the rivalry between Michigan and Ohio. Like, whatever. It means nothing to me.
Smart man.
And then turns out you're both like diehard Cincinnati Reds fans. And I was like, oh, I didn't need to say that, I guess.
Well, DJ and I both care very little about sports, except for the Reds baseball, because, the Reds are America's team. And people may disagree with that characterization, but they're wrong.
Well, the other nice thing is that when we were there, the game we caught, they won. We saw a bunch of home runs.
Oh, I saw the game the next day where they got one hit. It was
really?
It was not a good game. But a day at the ballpark is better than a day at the office. That's all I can say.
Well, I had a lot of fun, and I think I've been to like one Tigers game, and it was like years ago, and it wasn't fun for me, and it's just the people I was with, I think. But this was a blast.
Good. I'm glad to hear that.
I understand sports now. I get why people want to go to the ballpark and have a good time there. And even the guys who were sitting next to us are just awesome.
Great guys. They had a good time. Yeah.
Yeah.
No, I'm so excited you came, and I hope the Reds was entertaining as well as argument. Argument was
that was a blast.
I think it went well. So I'll let you lead off. You tell me what you think.
Yeah. Okay. So for the people listening, I see we got 6 people watching now. We'll see if that number drops in a second. But essentially what happened is Brad is the national expert on attorney Banias or Banias. How do you say your name right?
Banias, you're good.
Banias. Yeah. Is the one of the leading experts on U visa work authorization, waitlist delay cases that are brought in federal court under the Administrative Procedure Act. So essentially, government's supposed to give us a waitlist decision for our clients where they get a work permit and deferred action. They've been taking, now it's up to 60 and a half months, they say is the average processing times, and we think that's unreasonable. And so Brad has brought a number of these cases. And as I was looking into this for some of my clients, I was doing some research on Fastcase, and I saw that that there's like a string of 18 cases, all in the same court, all out of South Carolina, all filed on the same day. And I was like, whoa, this is one heck of a coincidence that and it was the same attorney, and it was Brad. So we got in touch over Facebook. He did was very generous with his time. And I've mentioned him on this podcast before. Gave over an hour of his time just to sort of walk me through the whole process, then did a training on it, which we joined, and I got a bunch of friends to join too, just because he wanted. What was your motivation in doing that, Brad?
Yeah, so fair question. So a little bit about me. I come into immigration petition work from kind of the other side, meaning
the dark side.
I got into immigration because I worked for the government. And I work for the government in a very niche space, we'll say. And I left the government because Washington, D.C. is not built for everyone. And I got sick of being there and moved back to my home state of South Carolina. And, I was out and about with some folks who said, hey, here's U visas. These are folks that the police and law enforcement want in the U.S., and it takes 5 years. And that makes no sense. If you describe it like that, it makes no sense that it would take so long. And in fact, one of the judges, an 89-year-old man, looked at us and said, why would it take so long for people the government want here? And I think he hit the nail on the head. It makes no sense. It doesn't matter the volume of people filing. It doesn't matter how many adjudicators they have. U visas are a priority. They should be, because they benefit law enforcement. They benefit the police. They benefit the United States. And when I learned that a few years ago, I said, let's do this. Let's make a change. Let's make a difference. Let's fix this. And so, James, the cases you saw was a strategy choice, because it's easier for the government to defend one big case than it is to defend 12 small cases. And so we brought 12 small cases in South Carolina, which is not exactly known as a beneficial place for immigrants to file a lawsuit. But with 12 small cases, we were able to, and to be careful what I say, strategically engage with a judge that we thought would benefit us. And she did. And the case in South Carolina, those 12 cases we brought, ended up being 9 cases where we won at kind of the preliminary stage, and the government, when we get to the final stage, simply couldn't prove that 5 years is reasonable. And we built from there. So the cases James and I brought, we taught a class because a lot of people were asking about this, because if you win in South Carolina, ideally you should be able to win anywhere, because South Carolina is not exactly, again, a Seattle, San Francisco, Los Angeles, it's not.
It's not known as a radical district or that leans heavily one way or the other. That's right. I think district court.
And so I was getting a lot of questions about that. And so instead of fielding the questions individually, we taught a little class. And because of that class, I think about 40 lawsuits were brought. And we won a vast majority. And unfortunately, we lost a couple. And so, I reached out to James, said, okay, let's do this. Let's go to the appellate court, because the appellate court controls multiple states. And weirdly, strangely, idiosyncratically, the appellate courts have been much better on these cases than the initial court, the trial court. And I guess I'll shoot to you, James. What were your thoughts of argument? Because we lost in the trial court.
Yeah. So
but I think we have a good chance in the appellate court. What do you think?
Well, I think we had 3 cases in the Western District of Michigan. And when I read the decision on it, because the government filed a motion to dismiss, essentially saying that the court didn't have jurisdiction to decide this case, which is just silly, in my opinion, in my humble opinion, and I hope it's the Sixth Circuit Court's opinion too. And there's certain decisions where you read it and you're like, yeah, I guess we didn't have a really strong case. But then there's some decisions you read and you're like, I don't think they read this as close, the motions we filed as closely as they should have, because I think we got a really unfortunate decision there. So yeah, when we reached out, decided to do an appeal. And so essentially we just, we bring those in federal court, and, you file a motion, and the government, or not a motion, but you file the appeal, the government files a response. And then the court actually asked for some additional briefing on a couple big things, or at least one big thing that happened, right? The bona fide determination work authorization process that now allegedly exists. I haven't seen one yet. But it's definitely and the whole reason that USCIS put out this new work authorization that's already provided for under the statute. They're now finally deciding to implement it and label it as such. It's because of litigation. And I think it's the cases that you encouraged everybody and taught everybody how to file. Because they say specifically in their announcement, and we're not blind to the fact that there's actually a ton of litigation that we're facing about this. They flat out say that.
Well, litigation works. Even if you get a decision, or the policy change, or the agency changes their mind, not because of a particular case, it weighs heavy on them. they don't want to litigate. They don't. And they're willing to defend certain cases, but just what are we in July? So let's say 8 months ago, the prior administration wanted to end waitlist.
Yeah.
It was on the regulatory agenda. They wanted to get rid of it. And it took surviving that and pushing and shoving and kind of prodding to the front in front of courts that the judge asked at appellate argument, you should go to the front of the line. And unfortunately, there's no line. I wish there was.
Yeah. Yeah. And so in the case, I think in both of our cases, we weren't even allowed discovery. We didn't get that far. The judge terminated the case before we could even do that. And so that was one of the big things on appeal, the primary argument. And the first question that Judge Silner? Yeah. He was sitting all the way on the left. He was the only guy on the panel.
Judge Seiler. Yep.
Seiler, yeah. He asked as well, don't we have to get to jurisdiction on this first? And I thought your argument was great. It was right on point. Yes, this court clearly has jurisdiction. We have to make allegations that are reasonable and probable and likely and all the other things that has to be in a complaint. And under the standard that you need to plead those in an APA case, we did that. But the judge in the lower court said we didn't, but we did. And it's pretty clear that we did. And there's a bunch of other information that exists that we don't have because the government has it and they never had to give it to us and they still refuse to give it to us.
Well, and Judge Moore, who was the presiding judge, the judge who's technically in charge of the panel, said that later. Like, how are they expected to make these allegations if they can't get the information?
Right.
And that gives me heart. Like, we don't have to get a decision from the court that says, 6 months is reasonable or unreasonable. We just have to get where they can say, you can state a claim. And that'll make a huge difference for real people applying for U visas. Because as Judge Seiler, 88, 89-year-old man who's been on the bench since I was in elementary school, noted, like, these people are helping the police. What do we do with them? Is that fair? No.
I thought one thing that was really telling in his line of questioning, like in the questions that he was asking during both sides of the arguments, is, well, and when he said this, my heart sunk a little bit. He said, well, what is the status of these people? I mean, are they illegal immigrants? Are they illegal aliens? And I was like, oh no, here comes the party line. No, but that's not why he said it. He was asking, like, do they have a way that they can work? How do they work? How do they get a driver's license? How do they survive living here if they can't get a work permit?
Well, and I will say Judge Seiler, how do I say this? Unexpectedly was the one who wanted to know how this affected real people.
Right.
How did this affect folks who are just trying to live in the U.S., folks who've been victims of crime, who are waiting, who applied for this visa upon the promise that they would just get a decision. And he understood that.
And his questions reflected that. I saw a lot of nodding from Judge Donald and Judge Moore when he was asking. It's almost like he was asking the question that they all wanted to ask, because even Judge Donald and Judge Moore were asking, and they asked this specifically to opposing counsel, what would be reasonable? What kind of delay is reasonable in your opinion? Because we're looking at, so to me, it's like they were skipping over the jurisdictional argument. I think they had that resolved in their mind. Hopefully it's affirmative that we have it. But then we're like, okay, so what would be a reasonable amount of time under the situation for these people to have to wait? Is it 50 years? Is it 10 years? Is it 5 years? Is it 1 year? And counsel just refused to answer and engage in the hypothetical. And they stated, and this was the icing on the cake for me. They stated, well, Judge, that would depend. That would depend on USCIS's procedures. It would depend on how many cases they have. It would depend on their place in the line. It would depend on all of the things that we need to know for our complaint, which we would typically get through discovery, which we were denied.
Yeah.
And that's what the judge said. That's when she said, what you mentioned earlier, how are they supposed to get all that information?
Well, and again, for the folks watching, there's 3 judges in all of this, right?
Yeah.
And as a advocate in front of 3 judges, your job is kind of to go with the winds a little bit, where if a judge is on your side, that might be to convince one of the other 3 judges.
Mhm.
And the middle judge, not Judge Moore, not Judge Side, Judge Donald, I believe is her name. I could be wrong on that. Forgive
Nope,
me.
that's right. It's Judge Dom.
She was the tough one, and she asked the typical but tough questions. And when what we see this very commonly in appellate cases, where appellate courts, they want to set the rule for all of the courts below them. So Michigan, Ohio, Tennessee, right? Sixth Circuit.
Kentucky? Is Kentucky in the
Kentucky, obviously. Sorry, one of my kids from Kentucky. But they want to set the rule for all of those judges below. And so they often seek the line. What is, well, if this case isn't it, what is it? And that's what Judge Donald was doing. And to have a government attorney who they implicitly trust because of the government.
Yeah.
And I can say that because I used to be one. You know, you walk in, you are charged with a higher duty, I think, as a government attorney. You're expected to know the answers that the private attorneys, James, you and I don't know.
Mm-hmm.
And
like how much time is reasonable?
That's right. To avoid the question like they did. I mean, if you listen to the argument, Judge Donald like scoffs audibly, because she goes, well, is 5 years reasonable? And the government attorney goes, well, I don't know. Is 10 years reasonable? Mm-hmm. Well, I don't know. And he goes, and that's because she expects them and wants them to answer the question. And
because there's got to be some amount of time that is patently unreasonable, and that's what they want to establish. And I mean, on the government side, it was just over and over. Well, we're not going to engage in the hypothetical, but hypotheticals inform principles, right? And inform what good law should be.
Well, and James, I think you probably kind of like cringed when I got up and I said, I can answer that question.
I love that.
You.
I was into it, man. That was like 10 years better than the movies.
Well, we got up and I explained to the judge why a 10-year delay could be reasonable. And a 10-year delay could be reasonable if every 2 or 3 months something's happening, right? Yeah. If we're sending investigations and we're doing blah, 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 and we can all imagine a scenario where the person applies, there's legitimate fraud concerns, maybe terrorism concerns, where investigations keep going, they keep going forward. And so a 4 or 5 year delay, because things have been moving the entire time, is reasonable.
Or let's say a police department is under investigation because they've issued hundreds of thousands of U visa certification.
Fair. Yeah.
And they were doing it for pay, and they're being investigated. It might take 10 years.
Yeah,
that might be reasonable then if that's being investigated, you know.
And here's the kicker: if that's happening, the people who are the who are subject involved in that aren't going to sue. and the real reason I embraced that hypothetical is to show them that's a far cry. It's not happening here, because in our 4 cases, 4 families, they don't claim there's fraud. They don't claim there's birth certificate issues. They don't claim they don't know who these people are.
And in our complaints,
it's on a shelf somewhere, and we should be able to not have to look at it.
Yeah, and in our complaints, we allege over and over the issuing of this waitlist decision is a ministerial duty. It is a check, check, check. These things are present. They're on the wait list. So it's,
and I think one of the more convincing moments in our argument was, we explained that with this new bona fide determination memo, the BFD memo, so to speak, they don't have some sort of super secret definition of bona fide.
Right.
It's routine. It's you literally look in the dictionary. It's what it says.
Yeah.
And that's it. And we brought that up and I said, look, judges, this is routine. This is dictionary definition. And their litigation position was, it's so complex. We don't know.
Right. They said that a lot. In fact, they said, we don't have the resources to determine if these are bona fide. We don't have the resources to figure out if it's really this, and we don't even know what bona fide means. It's undefined. It's mysterious to us.
And this is what it's. This is the sadly a common tale when you litigate against the government. I mean, for USCIS to put out that memo, right?
Yeah.
The BFD memo, which I'm really, really happy they did. It's a long time coming.
Yeah.
I mean, literally like 13 years. But it takes time to, approve certain things, and has to go through different hierarchies and all this kind of stuff.
Survive an administration change.
Exactly. But at the end of the day, they're not communicating with the folks we're dealing with.
Right.
It's so compartmentalized. And
it seemed almost disingenuous to hear government attorneys say, oh, we feel so bad for them, but there's just nothing we can do. There's nothing we can do for them. We know they have to live 5-6 years without a driver's license, a social security number, the ability to work, get health care, get health insurance without getting later sued by the health insurance company and going to federal prison because of it. But we feel so bad for them, but that's too bad.
It's interesting. So I worked for the government for a little more than 3 years, and I didn't physically see the client on the other side until about 18 months into my job, because the government wins usually on papers. And I remember going down to New Orleans to the Fifth Circuit to argue, and meeting the person on the other side. And it floored me, because that's a real person. And when you're in DC in a windowless office, it's just paper. But when you meet the person and you see they're a human with children, it's eye-opening, and it shouldn't be.
Right.
It's silly that it took me a year and halfway through my career, and I won a lot of cases before that, because the government wins.
A year is not halfway through your career, though. Maybe at the time.
No. But it was. I remember getting on the airplane to fly home and going, "Wow, that's the first time I've met a person. He was a nice guy, smarter than I'll ever be. For that particular case, he's a banker with very sophisticated, business knowledge. And I was there to do my job, and we won the case. But, it's the government attorneys, like you saw, they see names on a piece of paper. And, one of the most disheartening things is, one of the most disheartening things is to have, at the beginning of our case, you notice this, the clerk of court announcing the cases made a joke out of not being able to pronounce our clients' names, which is silly and little, and who cares?
It was a joke, but it was lighthearted. It was like,
it was, but
it's a little dehumanizing, though.
It's when you really think about the big grand scheme of things, that's hard. Just because Mr. Aguijo has a name that derives from a different country doesn't mean he should have any less process. And it's tough for that. And I feel like, I think, James, you saw this. And again, the standout moments in the argument we had were the 88-year-old white man judge going, aren't these real people?
Yeah.
That's
how are they supposed to live? That's what they are.
It's tough, and it's terrible that we have to go to the extreme lengths we do for them to be treated like real people. And
I thought in the rebuttal, you did a really skillful thing by telling them what would be a reasonable 10-year delay. And it really painted a picture for them. And then when you followed that up with, now in my other cases in South Carolina or whatever, or in Solis v. Gonzalez, right? When we got discovery, what the judge determined after reviewing everything that was in the record, evidence, exhibits, and things like that of record, is that a 15-month delay would be the upper limit on reasonableness. And do you know what? I don't know if you noticed this, but all three of the judges on the panel, they leaned back and, yeah, Yeah, to me, that's reasonable too. It was 100%. That's what they're thinking. I could read it, right?
They
And
all
that's
started
exactly-
writing notes.
Yes, they wrote it down. And for me, I mean, yeah, I think if there
Well,
is such a big
James,
line,
you do a lot of different immigration work. If you had a marriage-based couple, straightforward, 15 months is a long time, but you can make that work, right?
yeah, I mean, typical processing times, at least here in Detroit, 7.5 months. And they have their residency, not just the initial work permit that comes in 4.5 months or earlier. So there's really no reason it should take 15. But supposing a couple things went bad in the case or a couple difficult factors arose, yeah, it could take 15 months, but that would be an outlier.
But 15 months is not something that like gets up your hackles. Like it's long, but it's not.
Okay, we got to file a federal lawsuit now.
Right.
Yeah.
It's not.
It's in that zone right before we lose patience on waiting with USCIS.
And I stand by this. Delay suits are very much incremental progress. We're never going to delay suit at the Supreme Court that says make a decision in 3 months. We're not going to happen. It's not going to happen.
Right.
So if the processing times, and we went into court the other day, processing times for U visas were 60 months. So a decision from the one appellate court that says it should be between, let's say, it should be 30 months. That's a huge step forward.
Yes.
Right? That cuts the time in half. And it makes, more importantly, it makes lawsuits for James, for you, to be more routine and more straightforward, because that court can't just kick him out. It has to take him seriously. The local,
assuming we went on jurisdiction,
right?
So we have all the 12B6 stuff.
Well, and,
we can start bringing those over and over, and we can say, look, the Sixth Circuit already ruled on this. I was there.
What I can say is, so the Fourth Circuit, where I practice, has already decided in a 30-page decision, they favored us for 3 pages, and they said no, you can bring these cases, and that's okay. And every case I filed since then has settled. Be it 18 months, be it 30 months, be it 40 months. We file a case, and within 2 months, they're getting waitlist. And as much as a lawsuit should not be necessary, believe it or not, even though all I do is file lawsuits, I'm a very not litigious person. It hurts me to have to file.
You could have fooled me at the Sixth Circuit Court of Appeals the other day, because you were fired up and ready. I mean, you were like fired up and ready. You were highly caffeinated, highly focused, ready to go. Because I know you had a Red Bull in your hand when I saw you in the morning, and then we went to Starbucks, and then we went to court.
Hey, you gotta do what you gotta do. You gotta do what you gotta do. But it shouldn't be that. This is what I do for a living, but my goal is to not have to do this for a living, not have to bring suits where people wait 3 years. It's
mind-boggling. And in the meantime, they've been the victim of domestic violence. They might still be in a relationship that they can't get out of because they don't have the independence to work or to rent an apartment, or fill in the blank. Everything that people need to do to be safe and live. Yeah. Life, liberty, and the pursuit of happiness. It all needs an employment authorization document.
That's right. And
that's a good slogan. I'm gonna trademark that. Life, liberty, and the pursuit of happiness all require a work permit.
Well, and it heartens me to see the agency do this bona fide determination process.
Yes.
I think that's what they should have done 13 years ago.
Yeah.
I'm a little concerned with the impact on the waiting list determination, because certain rights are accorded for a wait list versus BFDs.
Right.
But it's a huge step forward. It is. Again, I've yet to talk to someone or meet someone who's gotten one of these BFDs.
And like we talked about, when the court asked about it, You had the right response. It was, well, we don't know. I mean, they haven't told us anything. We haven't seen any. We don't know if they're going to stop waitlist decisions for now and only issue BFDs. We don't know how long that's going to take because they're in court. They said it was 264,000 pending petitions, which I don't believe. I don't believe that number was accurate.
That number's
They may
wrong.
have just been mistaken because they're not immigration attorneys. They don't look at the numbers every day like we do.
They're
I don't
wrong.
think it was
I think they're wrong on that.
It was exaggerated at a minimum. Yeah. And yeah, so who knows how it's going to play out, which is why we need to make sure we have that decision on jurisdiction, that we can bring these cases still, even though the BFD process exists, it still may be a long time until.
And it primarily impacts folks who are here who have family members or qualifying family members abroad. So if you're here, you're a victim of a crime, you apply for the U visa, and you have a spouse and children abroad, you don't want to leave. And in fact, the regulations say your family should be able to come here, period.
Yeah.
And that fits the underlying overriding purpose of a U visa, where we want the people who can help prosecute the crime to stay in the U.S.
Yeah, and we want them to have deferred action in the meantime, because it's going to take 10 years or more to get the statutorily limited number of visas per year. And in the meantime, life happens. So we had a client about 2 months ago, just like crying, like literally falling on the floor crying, just a wreck, because her sister had been attacked by some ne'er-do-wellers in a foreign country in Central America. And the sister was sending like photos and videos of her all bruised and bleeding, lying in a hospital bed, couldn't get up. And it was a sort of thing that had happened in their against their family before in the past. And because this client of ours was here in the US, she missed the death of her father and was afraid now that her mother, who was on her deathbed, because all this trauma is happening to the family, she's afraid she's going to miss that too. Life happens in those 60 months. And fortunately, she had already been issued a U visa and had an adjustment pending, and we were able to get advanced parole. So she was able to travel on that and be there for those things. But if you get I don't remember right now. If you get a BFD, did they say that's going to include deferred action?
Oh, yes.
Okay, good. Well, hopefully then someone in deferred action on the BFD.
But not necessarily parole.
Travel.
Not necessarily parole. So it's tough because 5 years ago, I didn't have kids. My life has changed drastically in the last 5 years. And that's, I'm saying that from a point of privilege. I recognize that. Like, I love my little ones, but life is very, very different than it was 5 years ago. I can't imagine applying for a driver's license and not getting it for 5 years.
Right.
What these folks are applying for is so much more significant, meaningful, and risky. It's risky to testify against people, right?
Yeah, it is.
And
because eventually they might get out of jail and they might have a grudge or an issue to pick with you. I
mean, that's right. And and the law recognizes that, right? There's all sorts of protections in place for confidentiality and all that kind of thing. And these are folks that Congress said we should protect, prioritize, and in practice, they are the least protected and the least prioritized. And that's what hurts my heart. That's what makes me want to fight for these folks and go to appellate courts. And so I should say we won in the Fourth Circuit. I tend to think we have a good chance of winning the case we won, or we argued earlier this week.
Yeah.
That's two. We got to get a third circuit because the agency has a rule. If they lose in 3 circuits, they revisit the policy. And I'll tell you this, like my firm, totally different from U visa stuff. We lost a case in DC this past week where it's 10 circuits against us.
Oh, wow.
And so they've won in 10 circuits. They lost in 1. So they keep fighting. But the reason we brought the case is because we know if you overcome it in 3 circuits, that's all it takes.
Yeah.
And, that case will go to the Supreme Court. That's neither here nor there. But for this particular type of case, under this particular administration, now is the time. Now is the time to push, shove, prod, fight.
Get the bureaucracy to move. Get it to respond.
That's right. And if I'm correct, the two judges that ruled against us were Trump appointees. And this is not a political statement. By being a Trump appointee, they're baby judges. They have to be. They cannot be in practice for more than 4 years as a judge, right? And judges, I've worked for two. I love my judges. One is now deceased, sadly. One's still very much alive. But they will both admit they matured. And they learned things, and they, learned what it means to be a judge. And these judges, I don't think they're there yet. I just don't think they are. And
you're talking about some of the Trump appointees, some of the recent appointees to the federal bench.
That's right. I think when again, fingers crossed, if we win this case, it's going to teach them a lesson. And not in like I'm not being like, I'm not trying to be, I know better than them, but you can't just throw immigrants' cases out. You can't.
Yeah. And
I'm very excited to see that. Assuming we win, I'm very excited for them to go back and get their day in court, because that's what's been deprived.
We got a couple people who've submitted comments here. We got one from Mohammed Monrul Islam. Is there any possibility to reduce the waiting time for U visa and increase the caps 10,000 to 30,000? Do you know if there's any pending legislation for that? I don't think so either. So with the BFD process, that may speed up getting the work permit at least. The 10,000 per year, we're stuck with that unless there's some other reform that gets proposed.
That's right. 10,000. The 10,000 we can't fix through lawsuits. It's
that's fixed by statute. That's call your congressman to do that. We have another comment here from Nivanjar. It's been a year. Applied U visa still haven't received biometric. They haven't even received their fingerprinting appointment yet. That's a long time for fingerprint appointment.
When do you see biometrics, James, in these cases?
Typically within the first couple months. I mean, there may be something wrong with your case, my friend. And I don't know who you really are, Nivanjar, but I would say contact your attorney, follow up on your case, contact USCIS, because if it's been a year, something went missing. Definitely. Well, and get received and biometrics will be issued much quicker than a year.
Well, a year ago,
he must have submitted it during COVID. Sure. Who knows what happened to it then? Could be anywhere.
Which is even more reason to follow your advice of call them, see what happens. Biometrics are a thing that if you've entered the country recently, they can reuse, and they're starting to do that more. So
yeah. We also have this from him. When USCIS might publish BFD timelines. Once they start approving them, once they start doing them. And they haven't yet, as far as we can tell. So
no.
There's one more case I wanted to talk about, a case that you brought up during oral arguments, and it is the famous MASH-P. And I thought you did just a wonderful job of explaining it, because I think it's the most poorly understood case that is cited by the government in defense of kicking all these lawsuits, because according to them, as attorneys, all we're doing is saying, put Timmy in front of Susan. Just let that person jump the line. And I thought you had a really good explanation, because what you did is you said, all right, judges, this concept comes from this case that's cited over and over by government counsel, and it does not really apply at all to immigration cases. Do you want to just talk a little bit about that?
Yeah. So the MASH-P case has had a inordinate impact on delay cases. So let me talk a little bit about MASH-P case. The MASH-P are a group of people who claim that they should be considered Native Americans under the appropriate statute, meaning they could have a reservation, they can have all the benefits that are associated with Native American tribes, and those are significant benefits, right?
Yeah.
Um,
It gives government a large amount of governmental autonomy.
yeah. So huge. I mean, huge.
It's a big deal.
But think about what they're asking. This group of people qualify for this, right? What does that mean? Historically, practically, and even today, they're still there, right? And this particular piece of land. It's a hard analysis. And in fact, the statute that allows groups of people to be considered Native Americans for all the benefits that Native Americans get, and they should.
Under treaty, usually, because they signed a treaty and you got to follow the law, because that's the supreme law of the land, just like the Constitution.
Exactly. Like, it's incredibly difficult, though. I mean, we're 200 years into this experiment of America.
Yeah.
And this is
You've seen extermination, a flat out extermination of certain tribes.
That's right.
Countless oppression over the years. And so there's some people who may be descendants who have, a 1/16th or whatever portion of descendancy from those tribes, who want to say, no, we want to restore our culture now. We want our borders, our language, and our culture back.
Which is completely fair.
Absolutely,
Please do not construe anything I'm saying as negative on them at all.
Right.
It's not. But because it's a complicated analysis, right? What Congress said was you have to have a PhD in history, a PhD in sociology, and a PhD in what was it? I want to say geography or something like that. And Congress in the law said you have to do these three things. You have to demonstrate A, B, C, D, E, F, and G, and here's $1 million a year to do it. Which $1 million a year sounds really nice. But it's not that great when you have to run an entire federal program. And so Mashpee, the case basically says, we have 10 groups of people in the United States seeking this designation. And for each application that gets sent in, we use all of our resources. So everyone in our office focuses on one application at a time. We don't have 200 people, right? We're like 20 could be focused on application A, 20 could be focused on application B, 20 could be focused on application C. That's not how it works.
I think they had something like 5 total people working in that department.
That's exactly right. Yeah. And so in that particular case, what the court said in DC was, well, if you're using all of your resources to focus on one decision, and there's 10, pending. Well, that makes sense. If we're going to push, application 6, sorry, I'm trying to do this on the camera. Application 6, the front of the line. Well, the other 5 are going to get pushed back. Yeah, that's fair. That makes sense to me.
And I think before, and we'll finish the case thing, but just the analogy of thinking about a line. And what we as humans feel as justice is like, if you're in line at Disney, well, and there's people who pay for the privilege, right? But if somebody doesn't, and they just try and cut the line, it's highly offensive. It's like, it's against our primitive monkey brains that somebody would dare cut in front of us. That's our spot in line. How dare you do that? That's unjust. It's unfair. And it's unfair to everybody else behind me. So it's the argument that it has a lot of appeal just because we're saying there's a line and they're skipping the line. That's the thing that fights start over in kindergarten and in first grade, in second grade, third grade, elementary school, all the way to high school, all the way to Walmart on a Black Friday. You cut the line, I'm going to beat the crap out of you, and you might die because of it. So the fact that they're trying to use this case saying, no, there is a single file line. Everybody has their place in it. It is fixed and it's fair. Well, you're going to tell us why it's not quite like that. But I wanted to point that out because just from a pure, I think, evolutionary standpoint, the idea of a line is fair.
Well, and I think at argument, I said, it's intuitive. It makes sense. It would seem like it's harder for them to decide it not in a line. But that's what we see. James, we got information after we filed these cases from the Freedom of Information Act. And I literally have on my computer a spreadsheet of everyone who's been granted waiting list terminations. And when they filed and when they got approved, there's no rhyme or reason to it. Like, some people get it in 3 months, some people get it in 3 years. And so for the cases I've been able to bring since then, which was not the cases we had in the Sixth Circuit,
right?
I can literally allege, 3,472 people have gotten decisions since this person filed. Right? And
that is not a straight line, my friend.
It's absurd. And but when you sue the government, you're always at a disadvantage. And I'm now 3 years into this, what I would call project, and we're just now getting those facts. Just now.
Wow.
And I've been fighting hard for them. And to disprove this intuitive idea of a line takes facts. It takes FOIA, Freedom of Information Act requests. It takes folks who are willing to take a risk, right? During argument, I had a case from North Carolina where we defeated the motion to dismiss, and they all won. And it was 81 people. 81 people got, quote unquote, pushed to the front of the line, which is, there's no line. So
and that was one thing that Judge Seiler said is, and he said it to the government. Well, if you could do it for 81 other people who filed a lawsuit, why can't you do it to these folks?
Well, and what I want to tell the government is, and this may not be the nicest thing to say on this. Some folks may want to wait. Some folks may not want an immediate decision, right? Some folks may say, well, with ICE in my particular town in Idaho, if I have this pending, they're not going to bother me. And so a 7-8 year delay may be fine to them, right?
It may be a shaky case to begin with. At least if it's pending, maybe they won't get removed if anything happens in the meantime. Because there are cases, they're not all approved.
No.
There are cases where, for example, as the attorney, we say, okay, this person was the victim of a real good beating. There were no weapons used, but this person took their face and smashed it against the concrete multiple times. In this case, we believe that the concrete acted as the weapon because it was used to enhance the power of the smashing with this person's fist. And there's actually a case in Massachusetts I found, and I think there's a statute in Massachusetts that permits that interpretation of an assault, where if you hit them against something hard, that counts as a weapon, I guess is what they say. Which can be the difference between a felonious assault and just a regular assault, which may qualify them for a certification.
Well, and when judges say, well, this will open the door to everyone, I want to go, no, not everyone wants a decision at 4 years, 3 years, 2 years, 1 year. And there's strategic reason for that. And I think this, maybe your viewers will say, oh, you don't know what you're talking about. I don't do U visa applications. I don't fill out the petitions. I don't submit them. I think that gives me credibility in front of a court, saying, look, I'm just a hired gun to come in and do this. And it allows me to say, well, some people don't want to do this. And some people do. And my clients in this particular case are waiting. And James, you saw this at the end of my argument. I pivoted. I looked at Judge Seiler.
Before we do that, I'm going to write that down. Okay, because I wanted to finish on the Mashpee thing, because
yes, please.
When you were explaining the whole concept of a line to the court, you said in this case, the USCIS has 2 service centers that can decide these now. They have, I don't know, 85 here and 50 over there. So there's over 150 people each day who are doing nothing but deciding these cases. And based on their capacity, they should be able to do 40,000 or so of these a year. Last year, they did 20. So it may not even be a a constraint on resources issue, but we don't know because we haven't done discovery and all this stuff. If this is a line, it's a line 150 people wide and then however many people deep. Moving somebody to the front of here is going to have a de minimis impact on anybody else and may have no impact at all. And I think as a practical matter, the fact that we have these lawsuits and we get these people a result is going to incentivize USCIS to do what they've done with the BFD process and do something to make it go faster. So it's actually not just moving them to the front of the line, it's making everything go faster for everyone because it has that effect.
No, and as much as the government will disagree with me, I say this, litigation works. It does. It speeds things up. And it's, while someone hires me to bring a case and I'm just focused on them, it helps the whole community. It does. In South Carolina, we see decisions faster. In the Fourth Circuit, we see decisions faster than everywhere else in the country. And I'm excited for that. I'm excited for my people, you know? I think they should be decided faster for everyone, whether you live in Idaho, California, Virginia, Texas, because sadly, this program is so important. It is. It's an important program. Has been overlooked and treated with disdain, and that hurts my heart because people who God, I can't even imagine, you know, having someone come in and put a gun in my face and rob my store, and then being brave enough to call the cops and testify against them, and then be told, oh, by the way, you can get immigration. Great. It's not why I was working at that store that day. But then to be just considered, well, treated terribly.
Yeah.
It's just as Judge Silas said, these folks should be pushed forward. They should be treated better. You know, like I represent a lot of very smart people who have college degrees and get visas based on that. U visas should be treated better than those. Yeah. Because they didn't choose this life. It's a
humanitarian visa. It's very human. So let me share one case because we do, you know, we do file a lot of these and we have filed a lot. We had one client that we filed a U visa petition for who they were the victim of a shooting. Like they were shot. Like we had the medical records, police records, everything. And they testified against the guy who robbed them and shot them. Well, because they had the misfortune of being shot, they needed medical treatment. Well, they were working. This individual was working. As part of applying for the job, they signed him up for medical insurance. And I'm going to call out Blue Cross and Blue Shield Michigan because these jerks, what they did is whenever anybody files a claim that's big like that, I think there was in excess of 5 figures in the amount of dollars that needed to be paid for his treatment because he was shot by a criminal and robbed and then bleeding, could have died. But what they did is they checked their records and they say, oh, this social security number doesn't match up. Oh, and this name doesn't match up. And oh, well, we better send it over to the police now. Michigan State Police investigate. They bring him into federal court. On what? On insurance fraud. Because they say, oh, you weren't actually married to your wife, so you shouldn't have been included on her health insurance. And so now you're facing federal felony charges, which we did our darndest to get rid of or to get pled down. But the fact of the matter is, both he and his wife ended up serving time, even though we had filed a U visa petition for both of them. And in dealing with USCIS at the time, they said, because we asked them, hey, can you please push these guys to the front of the line? they're facing felony charges here. Is there anything we can do to legitimize them so that, we can help them? Because really this wasn't their fault. It was this paperwork stuff. And he really was paying his insurance premiums, and he really was married to his wife. So he really should have been included anyway on that. And what we got back from USCIS was we recognize the irony that he was the victim of a crime which caused him to face federal felony charges due to the insurance issue. But as a discretionary matter, we're denying it because he has now a felony record. And that was his only criminal offense. And so you ended up with these people facing time in federal prison and then facing deportation. Even though they were the worst thing they did here was get shot by somebody else.
Well, this goes back to the entire idea of, our immigration system in 2021 is based on what the international culture looked like in 1952, right? I mean, the Immigration Nationality Act was passed in 1952, and I can get to England in 4 hours now, and people legitimately work in Greece and the U.S. 6 months out of the year, where in 1952 they couldn't. Like, we need a complete rethinking. But there's no legislative interest in that.
I think there would be if you told Congress, hey, you guys can all work remotely from an island in the Caribbean if you do this. Because people, their whole careers now, even attorneys like us, we can handle all of our appointments via video conference, via telephone. We can be on a beach somewhere and doing our work and carrying on life.
Well, I will say, my as much as I enjoyed Cincinnati and going to the baseball game with you and seeing everything, that was my first in-person argument in a year and a half.
Yeah,
I've done arguments in the Second Circuit, the Fourth Circuit, the Fifth Circuit, the Fourth Circuit, from my front office, from the office in my home, like my front bedroom, frankly, and it did fine. And
so I think that a good thing sort of to end on here, since we're coming up on an hour, this has been awesome. Thank you very much.
I hope so.
I want you, because
I'm not good at this. Just for the record, I'm not good at podcasts and sound bites. I'm sorry.
Yeah, you are. You're natural. Anyone who can easily go in front of the Sixth Circuit Court of Appeals and argue a case and field questions and do answers and come up with things, just from a sheer experience, is a natural in a podcast environment. So lawyers make the best podcast guests, lawyers and comedians, because they have to have the same skill set with communication.
Sure.
But the last thing you did in your rebuttal, so the very last words that you got in arguments, it surprised me. And it surprised me, it pleased me, because you delivered it so well, right? But I was shocked, because we, as lawyers, we know that when you're in front of a panel, it's like Matlock, just the facts, ma'am. You're really supposed to go facts, law, facts, law, facts, law. And typically, if none of those work out in your favor, if none of those are on your side, like my professor from Cooley Law School, Mike Dunn, would say, if the facts are on your side, you hammer the facts. If the law's on the side, you hammer the law. And if neither of those are on your side, you hammer the podium. But you brought what you did is you told them about, like, the humanity, about the clients that we're dealing with. And what you said, I don't remember word for word, but it was, look, these are real people who have to live in a world where they can't work legally, where they can't do this legally, they can't do all of these things. What made you want to add that, which is typically not, I mean, at least in my experience, typically not done in an oral argument? What made you want it to add that to the record?
No, I, as a lawyer who's interested in bigger thoughts, like checking Article 1 with Article 3, and it gets really nuanced and nerdy. I mean, at the end of the day, my clients still can't work. And my clients' kids can't go to college. And that's what hurts. That's what is absurd, because they want to. They have great claims to being quote unquote American. They've been here 20 years. And they've worked really hard, and they're business owners, and they're creating jobs for other Americans because out of necessity. And at the end of the day, do I think that a child of someone who owns 2 gas stations, right, should be able to go to school at the University of Kentucky? Yes, absolutely. And the fact that they're going to say no because their parents brought them here as 5-year-olds, that just really irks me. And as a parent of 2, if someone told that to my kids, I would want to punch them in the face, right? And you know what? My clients are no different than me. They're fathers, and they want the best for their kids, and they've done everything they know to get the best for their kids. And this weird, they're being told no because of weird nuances in jurisprudence. Doesn't add up. And it hurts. These cases really hurt my heart when it involves kids and parents too, because they're doing their best. And but we have more than one plaintiff who was a kid. And I don't care if you're 20, you're a kid. And that kid should have every opportunity that my kids have. Because
they're kids. They're vulnerable. They're tiny human beings.
I love my kids, but they have no idea. They're so lucky they were born where they're born.
Yeah.
That's a lottery. Like, we could have been vacationing and they were born in Thailand. Who knows? And then they'd have all these problems. But it hurts my heart that people come here to establish a better life. They have kids here, and the kids suffer. I'm not. Here's the thing. I'm a lawyer. I'm not willing to put up with that. I'm not going to. I'm going to fight that every day of the week. Money aside, it doesn't matter. I'm going to fight hard for those kids. And Judge Seiler, who again, 88, 89, a Republican appointee, that was the only thing he picked up on. What about these families? What about these real people? And we can talk about Mashpee, we can talk about all this stuff, but these folks are real people who, by definition, have gone through stuff that James, you and I have never gone through. And just, of all the people our system should be helping, this is them. This is it. Like, and again, my goal with the last, 1 minute of my argument was to put forward, look, these are not people you should be hurting. These are the people you should be helping. And I think I hope it hit home. I don't know. This is also why I believe these cases, we should bring them every time, because U visa applicants are, how do I say this? You're doing what I could never do. You are brave, you are strong, and more power to you. I don't have that in my makeup. And thank you for having that. Thank you for fighting. Thank you for saying, I was a victim of a crime and I'm willing to fight even though I'm vulnerable. Thank you for that. Like, I don't know. Sorry to get cheesy, but
no. And you know what? I think in cases where the facts and the law, there's a reasonable interpretation for both, that human touch is what can really take a judge who might be on the fence and say, it could really be either way. Why don't we just help the people as well? I mean, let's do the interpretation that's helpful to the world. So it's, Brad, you're an inspiration, man.
No.
Thank you.
No.
Because I wouldn't have been able to bring any of these cases, and there's some that we've won and some that we didn't win, but I wouldn't have been able to bring any of them without your help and your mentorship, training, and your time, which you've been very generous with. And it's been huge for my clients.
Well, I'm hoping we can fix things for clients in in Michigan, Ohio, Tennessee, Kentucky.
Yeah, and if there's any other attorney listening out there and this was at all interesting to you and you happen to have any pending U visa cases in any other circuit in the U.S., yeah, reach out to us. Send us an email.
We need one more circuit.
Yeah, it sounds like if we get one more circuit, then it could change it for everybody. And that's phenomenal.
Thank you, James. So, thank you for doing this.
All right. Brad, thanks a lot. Have a great day.
All right, my friend.
Sign off here. Okay. All right. Thank you for joining us again. This show is brought to you by Prima.Law. Prima.Law is online case management with immigration forms, California forms, Michigan forms, New York forms, soon to be adding Florida as well. So if you're an attorney who practices in any of these places, Prima's for you because it can help you autofill those forms that you need when you're filing cases and doing casework. Now, if you are an attorney who practices in any other practice area or any other part of the United States, Prima.Law is also for you because we have a lot of great core case management features available for as little as $10 a month. It includes texting, so you can text your clients right from the platform, billing, online payments, invoices, payment plans. We just released a new client portal as well. It's a beautiful and easy way for your clients to upload documents to a checklist for their case. If you want to learn more, please check out our website at Prima.Law. Sign up for a free trial, and you can get started today.